In part one of this series, we heard Mitt Romney and Newt Gingrich make the case that individuals suspected of treason or aiding the enemy are not subject to due process and the rule of law. This justified their support of the National Defense Authorization Act. Romney and Gingrich are not alone, however. 65% of the House of Representatives and 86% of the Senate voted for passage of the bill. Perhaps the most pronounced argument was made by South Carolina Senator Lindsey Graham regarding persons suspected of aiding the enemy.
And when they say, "I want my lawyer," you tell them, "Shut up.
Your time is
Don't get a lawyer."
Shut up. You don't get a lawyer. The Miranda rights equivalent for the war on terror. How could anyone espousing this horrific bastardization of justice hold elected office? How can someone who lives in the land of the free not understand that there is no justice without due process? Let's construct a plausible example from recent events that illustrates the danger of this short-sighted and ignorant view of justice. Anonymous is a decentralized network of hacker activists who have employed illegal and disruptive means in order to call attention to government and corporate actions that they perceive as unjust. The 2012 NDAA expands the definition of enemy forces beyond Al-Qaeda and the Taliban to include the vague term associated forces. This allows the government great flexibility in defining exactly what organization your support of would justify indefinite detention without trial. Furthermore, the NDAA does not limit the type of involvement which would classify you as an enemy combatant to the stereotypical engaging in actual combat operations, but uses the vague term of substantial support. These two open-ended terms could transfer something as innocent as a donation of money to a charitable organization, normally considered an expression of free speech, into providing substantial support to an associated force if the government can find any way to link the activities of that organization to some other terrorist effort. In a recent hacking, Anonymous infiltrated the computer systems of a security firm and retrieved the financial information of many of its members. As part of its protest, the group used the information to give donations to various charities. In this case, the group publicized its actions, and the victims involved had visibility which allowed them to contest the charges to the charities. Now, let's remix these events and provide a scenario that illustrates the need for due process. What if the hacker group Anonymous infiltrated the computer records of Senator Lindsey Graham and used his information to donate money to one of the many charities identified with ties to terrorism? Let's suppose that the same standard is applied to him that he advocates for anyone else suspected of providing support to affiliated forces. He would be given no trial or hearing in which he could contest the facts or make the case for his innocence because of that well-thought-out legal argument,
"Shut up.
Your time is
Don't get a
expired.
lawyer."
In reality, if this were to happen to Lindsey Graham, the law would not go after him since he would be presupposed innocent as a representative of his state. But what if Anonymous secretly did the same thing to regular people with no claim to any special privilege? Would there be a presupposition of innocence? If it happened to one of Senator Graham's own constituents, would he fight for their right for due process? Or would he advocate the following in place of Miranda?
"Shut up.
Your time is
Don't get a
expired.
lawyer."
If your representative voted in support of the NDAA, hold them accountable at the next election cycle if you can't recall them immediately. How did we get to this point? How did we as a nation go from giving our life's blood in the name of freedom to applauding power-hungry hegemons who openly hold our liberty ransom in the name of fear? Our government is only endowed with the power and authority delegated to it by its citizens. If the people divest themselves of the very principles which would guard against tyranny when courted by a well-meaning and benevolent custodian, what recourse will they have when the next aspiring autocrat ascends to power? Some will acknowledge the overreach of power that the NDAA represents when speaking of U.S. citizens, but make allowances when dealing with non-citizen suspects.
I do agree that if you are not a citizen of this country and you are picked up in armed insurrection or trying to destroy this country, that you can in fact be detained and be detained indefinitely without the right to a lawyer or to a habeas corpus petition. And I would detain them and get them. That's my position.
The idea that the government gives basic civil liberties to citizens, but is not restrained in denying them to non-citizens, ignores the fact that the Constitution does not bestow rights on citizens, but rather restrains the government from infringing on the rights of persons without regard to nationality. This key difference was central to the philosophy of America at the time of its founding, but has been ignored or concealed in the rhetoric of today. Those citizens that believe that this distinction removes from them the need to be concerned about civil liberties in the War on Terror should ask themselves why there is a bill under consideration, the Enemy Expatriation Act, which would remove the citizenship status of anyone accused of the same vague support of enemy hostilities that the NDAA refers to. Only by understanding that the civil liberties described in the Bill of Rights are pre-constitutional and apply to all persons by nature of their humanity, citizens or not, can we protect against our government's inclination towards unabated power.